Hello, you're watching Addleshaw Goddard's Employment Channel. On this week's programme, we look at two significant decisions spanning the entire spectrum of employment law. Our first case comes all the way from the European Court of Human Rights and looks at freedom of religion in the workplace. Slightly closer to home, our second case has important consequences for terminating employment contracts and making payments in lieu of notice. First up today then is the widely reported case of Eweida and others in the UK, heard in the European Court of Human Rights, or ECHR for short. Here the ECHR considered whether the UK had sufficiently protected 4 different employees against discrimination for expressing their religious beliefs in the workplace. Each took their case to the ECHR after losing their claims for indirect religious discrimination in the UK. Miss Eweida and Miss Chaplin wanted to wear visible crosses at work, which breached their employer's uniform policies. Mr McFarlane and Miss Ladale had refused to provide counselling and civil partnership ceremonies to same-sex couples. They all argued that the UK hadn't protected their human right to express their religious beliefs or their human right not to be discriminated against. Employers can only interfere with these particular human rights where they've got a legitimate aim and the interference is proportionate. So here the ECHR had to consider whether workplace uniform policies can ban religious clothing and whether individuals in larger organisations can refuse to serve others based on sexual orientation. Most importantly though, the decision does provide some crucial guidance for future disputes of this kind. The ECHR found that claimants only need to show a sufficiently close connection between their act, like wearing a visible cross, and their belief, for this to then count as an expression of their faith. So, it doesn't need to be a strict requirement of their religion. Also, some legitimate aims, like health and safety, are going to be more important than others, like corporate image. For Miss Chaplin, who worked in a hospital, the health and safety risk that patients might grab her necklace with her cross on it outweighed the importance of her expressing her religious belief. This contrasts with Miss Eweida's case. Here, by a majority, the ECHR decided that her employer's corporate image was a legitimate aim, but the UK courts had given it too much weight. Her cross was discreet and there wasn't any evidence that other employees' turbans or hijabs had a negative impact on the brand. So, when trying to justify interference with a human right like this, employers will benefit from having some evidence demonstrating how the employee's expression of belief gets in the way of their legitimate aim. It's also going to be a good idea to be able to show some attempts to compromise. Finally, the ECHR said that where a legitimate aim involves balancing competing human rights and upholding human rights of others, so for example protecting others from discrimination, it will usually be easier to show the aim was legitimate. In addition, there'll also be a wider margin of appreciation for deciding whether balance should be struck between an individual's right to express their religious belief and their employer's aim in protecting the rights of others. Overall then, out of the 4 applicants, only Miss Eweida won her case. Where does this leave employers then? Well, here's Michael Leftley, a partner in Addleshaw Goddard's Employment Group, with some key steps and thoughts to take away from this decision.
Thanks, Helen. There's 3 main points I think we all need to take away from this case. Firstly, for legitimate aims, it now looks like corporate image on its own is going to be difficult to justify, where it stops employees from expressing religious belief at work, particularly where this is discreet and doesn't particularly impact on others. However, where there are other legitimate aims, such as genuine health and safety concerns, justification arguments are more likely to succeed. Secondly, as Helen said, claimants now only have to demonstrate a sufficiently close and direct connection between their religious expression and their underlying faith. It doesn't need to be a strict requirement of that faith. So it looks like it'll be easier for claimants in religion or belief indirect discrimination claims to prove a group disadvantage from application of a PCP, because it's going to be pretty unusual for no one else of that religion to share that particular belief. We expect tribunals going forward to take a broader approach to group disadvantage after this decision, so the main battleground is going to be around justification. And finally, check your policies. It's going to be a good idea to review these now in case there are any significant differences in how you treat mandatory or non-mandatory expressions of religious belief. These may now need relaxing. Overall, this decision is likely to require more employers to accommodate reasonable uniform requests based on religious belief, so it's best to consider these thoroughly at an early stage to avoid disputes or litigation further down the line.
There's been a lot of debate about this decision, including that the ECHR's approach was perhaps oversimplified by ignoring the UK's concept of group disadvantage and overly relying on a wide margin of appreciation to balance competing rights without thoroughly investigating those rights first. The Equality and Human Rights Commission has asked the government to amend the Equality Act to reflect that employers must now make reasonable accommodation for individuals' religious beliefs. So watch this space. Next, another big decision. Geys and Société Générale in the Supreme Court. A couple of pretty important contractual principles have now been clarified as a result of this decision. The first of these is that an innocent party must accept a repudiatory or serious breach to end an employment contract. Previously, either party's serious breach could automatically terminate the contract. So, where either an employer or employee seriously breaches an employment contract, it's now going to be up to the other innocent party to decide what to do next. Do they want to accept the breach and end the contract, or might they want to waive the breach and continue the employment contract for some reason? The second principle coming out of this decision relates to payment in lieu of notice, or PILON clauses. To terminate an employment contract with immediate effect under a PILON clause, employers are now going to need to check that they tell employees that they're exercising their contractual right to do this. Just paying the PILON on its own won't be enough to end the contract, mainly because employees shouldn't have to check their bank accounts to see whether or not they're still employed. Here, Société Générale paid £32,000 into Mr Geys' bank account, but didn't tell him or his solicitor about the payment or what it was for. The court found that Mr Geys needed to receive not only the PILON payment, but also notification from Société Générale in clear and unambiguous terms that the payment had been made under their contractual right to terminate his employment with immediate effect. Because they didn't send this letter along those sorts of lines until a few weeks later, his employment only ended on that later date, by which time he'd accrued an entitlement to €4.5 million under his bonus. Here's Michael again for his thoughts on this decision.
Thanks, Helen. This is a hugely significant case, both for employers and employees, and there's 2 points that I wanted to highlight. Firstly, where either party to an employment contract commits a repudiatory breach of contract, the other can really weigh up what they want their next move to be strategically. Do they want to accept the breach and terminate the contract, or is there a reason for keeping the contract alive? And if accepting the breach, the party needs to think about when it's best to do this. Here, Mr Geys gained €4.5 million by keeping his contract alive for a few weeks. Secondly, and a point for employers, when making PILON payments after this case, it's going to be really important to make sure that employees are clearly notified that you're relying on the contractual PILON right to bring the contract to an end, and that making the payment will operate to bring the contract to an end. Just paying the PILON of itself isn't going to be enough to do that.
Thanks, Michael. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.